know, the problem is that they're all gonna jump on it. They all want to start doing stuff.
Right now, I'm conflicted out. Or I should say we are.
Although we do have a few other issues on the docket today. I'm going to start a few minutes early since I see a lot of people here. We're going to start with the Oil Conservation Division's case number 25871. It is a notice of violation. Interest of appearance, please.
Good morning, Mr. Hearing Officer. Michael Hall on behalf of OCD.
Good morning, Mr. Hall. What is the name of the respondent?
Smith and Mars, Inc.
Okay, thank you. Is there anyone from Smith and Mars with us? I'm not hearing anyone. Mr. Hall, would you explain the nature of this case and your contact with the respondent?
Absolutely. The nature of this case is an inactive well, NOV. The operator, the respondent is out of compliance with the inactive well rules. In fact, they have 7 inactive wells out of 11 wells, and those other 4 are plugged but not released. The address provided to OCD as required by 1915-9-8 of MAC, I guess is not good. Our certified mail was returned to OCD, sent to that address as evidenced by what's happening here.
I think Freya will find the microphone is open. Thanks, Freya.
As required by MAC, that address is no good. However, Mr. Joshua Ogeen was an email contact provided. I did speak to him, and he said that he thought the principal, who he described as Ricky Smith, had notice of the NOV, and he said he thought he was looking to get a lawyer. I have heard nothing since. So in our opinion, this is a default situation, and we would ask for, well, first, may I proceed?
Sure, let me ask again, do we have anyone, because I saw some different people admitted. Do we have anyone from Smith and Mars Incorporated or Mr. Ogeen with us? I'm not hearing anyone. Go right ahead.
Thank you. OCD would offer exhibits 1, 2, 3, and 4 attached to our pre-hearing statement.
Admitted without exception.
Thank you. Based upon that, we would ask for an order, a plugging order for all 7 wells. And in fact, based upon their non-compliance with the operator registration provisions, as well as their inability to communicate with OCD regarding the 4 wells that haven't been released but have been plugged, we would like the ability to remediate those. So we're asking for an order regarding all 11 wells operated by Smith and Mars. Additionally, we are seeking civil penalties of $29,700.
Okay. Are you going to draft the order?
I would be happy to, Mr. Hearing Officer. One other thing, as pled in our NOV, we would ask that their authorization to transport be terminated. However, I don't think they have any production, but in an abundance of caution, we would ask for that relief as well.
All right, Mr. Hall, your exhibits have been admitted into evidence. No one from Smith and Mars has appeared on their behalf. So is there anything else?
Not from OCD.
All right, then we're off the record in this case. Let's move on to case number 2 on our docket. This is Burnett Oil 25778.
Good morning, Mr. Examiner. Ben Holliday appearing on behalf of the applicant, Burnett Oil.
Thank you, Mr. Holliday. I believe this is a redo from another docket, and have you submitted the additional information?
Yes, sir. We submitted our amended exhibit packet with the cover page. You're right. At the request of the division to fix some matters with the CPAC, we refiled our exhibits.
Perfect. And they've been reviewed and the case is taken under advisement. Thank you, Mr. Holliday.
Thank you, sir.
All right, we're off the record in that case. Number 3 on our docket, 2580.
Sharon Shaheen on behalf of Longfellow Energy.
Jackie McLean on behalf of XTO Energy.
Thank you.
Mr. Hearing Examiner, we actually reasserted our objection to this case yesterday. Yes, and so we would like this case to be set for a status conference on February 26th.
I did know that. I think that it's impermissibly late. They had previously objected and withdrew their objection. This case has already been heard. All we did was fix a few mistakes in the exhibit package. And I believe that this case should be taken under advisement.
Okay, I'll come back to you, Ms. McLean, in just a moment. Ms. Shaheen, is there authority for that statement that the objection is untimely?
I have not had time to look for authority, but it seems to me they waived their right to object after the hearing had already been held on this matter. And I'm happy to look for authority if that would be helpful for you.
Okay, and what we'll do is we'll recess this case. We'll come back to it at the end of our docket or before you leave, if you find something in the meantime. But Ms. McLean, based on, is there any authority for you to enter an objection at this time?
Yes, any part, while case is pending, any party can enter an appearance and object. We had already previously entered and objected, then withdrew our objection. And then now, the issues are not resolved. So we are objecting again because the case is still pending and that is permitted under the rules.
Why are you reasserting your objection?
Well, apparently the negotiations went south this week. So we were not objecting to them proceeding by affidavit, but then now at this point it is contested and we would like to move that route instead.
And not that this is fatal to your objection at all, but when you why did you withdraw your objection if the negotiations hadn't been completed?
Well, it was in good faith to continue the negotiations, allow them to proceed by affidavit. But their case is still pending. It was not taken under advisement. And, you know, we had entered an appearance. We could have filed a de novo hearing after this case, the order was issued in this case if we wanted to, because we had entered and maintained our appearance. So at this point, you know, I think it's permitted under the rules for us to reassert our objection.
I'm just reading, I'm on 1915-410. Obviously, you're an affected party who deserve notice. May enter an appearance at any time by filing written notice of appearance. This is under B, Ms. Shaheen. So I'll let you look at this further, but right now I'm on 1954-10B. A person entitled to notice may enter an appearance at any time by filing a written notice of appearance with the division, or subject to the provisions of subsection C of this rule, by oral appearance on the record at the hearing. Now, Ms. Shaheen, we are still at hearing because the hearing was continued for you to fix some issues with the case. So we're still at hearing. That's as far as the analysis goes so far.
And if I may.
Yeah, of course.
This is about entering an appearance. They entered an appearance prior to the original hearing. So we're not objecting to them having an entry of appearance, but there's nothing here that says, and they can object after the case has already been heard. In fact, if you take a look at subsection 12 or section 12, it says that when the applicant has given notice and those owners the applicant has located do not oppose the application, and I'm looking at 12.A.1B, the applicant may file under the following alternative procedure.
Mm-hmm.
A statement that the applicant expects no opposition, including the reasons why, and then it goes on to allow that case be heard by affidavit. And that case has been heard by affidavit.
I agree with you. You know, Ms. Sheena, I think at this point, without something more clear about their entry being improper, at this point, it seems to me that even if I didn't allow them to reassert their objection because negotiations have gone south, they have other legal remedies to interfere with your order, whether that be to reopen it later. That the rules allow reopening orders later under certain circumstances, or they can file a de novo appeal. I don't see how it helps you.
Well, it helps us because we could drill. The problem is there are expiring leases. And this includes XTO leases that will be expiring if we do not drill.
Okay.
And so I'm not sure why XTO is shooting itself in the foot here. They've, if they didn't want to withdraw their objection and expected some sort of settlement that they didn't get in the future, I mean, that's their bad business decision, frankly. They should have kept their objection. We would have gotten a contested hearing by now. We would be able, you know, ideally get an order to allow us to drill before the leases expire. But I'll stop there and let Ms. McLean speak.
I don't think I need to hear from Ms. McLean at this time. It seems to me that what I can do for you is set a contested hearing as quickly as you want. And I'll bend over backward to give you a contested hearing as soon as you're available. And Ms. McLean will just have to be available for that hearing. So when do you want a contested hearing?
As soon as possible.
As soon as, well, I don't know what that means to you.
Oh,
So why don't you communicate with your client while we go off the record in your case? Find out when your client's available. I'll talk to Freya when you come back, and then we'll let Ms. McLean know when the contested hearing is.
okay. I do know that the client is available on February 26th because I think that's already a scheduled contested hearing docket. But if there were a sooner available date, we would take it. So I will check with them about that.
Okay, but why don't you do that? And I know February 26th is fine. It's going to be virtual. I'll let you know now. We don't have this room, and I might as well let everyone know. We don't have this room from February 23rd until March 6th. The Environment Department's doing a rulemaking here, and they've already noticed it, so we're stuck with that schedule. That affects two of our dates so far, the February 26th and the March 4 hearing by affidavit docket. Ms. McLean, anything further from you?
All right, so should I get set February 26th aside? Okay.
I would. And in the meantime, Ms. Shaheen will find out if she can do it sooner. Now, I'm not available, Ms. Shaheen, from the 18th to the 25th. So it would have to be before the 18th if we're going to do it sooner, because the 26th is the first day that I'm back.
Okay,
Okay.
Thank you.
So we'll come back. Let me know when you're ready to discuss this date and firm it up.
I will.
Okay.
Thank you.
And we'll, Freya, how many cases do we have on the February 26th docket?
I don't have it pulled up, but I don't think there's that many status conferences, maybe less than 20. We
Oh,
also,
this is the one we talked about.
yes,
And then aren't there two NOVs that day?
correct.
And then there's then we have a contested hearing as well.
Yes,
Which case is that?
Carrasco.
Oh, you know what it is. Are you involved in it, Ms.
Yes.
McLean? Oh, you are. What's the name of the case?
Carrasco Estates.
And you're involved in it too. You've objected?
Correct.
Aha. And and you don't have, we haven't called this case, but you don't have a competing application.
Not right now. No.
I mean, we're set
No,
for a hearing.
I understand that, but that's where I'm at.
All right. Okay. So Ms. Shaheen, we'll make it a priority to get your case heard,
Thank you. I appreciate that.
of course. So we're not continuing, we're not taking this case under advisement at this time, but thank you for the additional information. So Longfellow Energy not taken under advisement.
Mr. Hearing Examiner, I have already gotten
Okay,
a response from the client. She's listening in.
great.
She says they are available on February 11th.
I don't know what date February 11 is. Hold on a minute.
A week from yesterday.
We're totally unavailable that week. But yeah, it's next week. And
Okay.
that's, no.
All right. I can, 26th is making it quick for you, Machine. The 11th is not going to work because I can't force them to be there.
I understand.
So let's say the 26th.
Thank you.
Okay, excellent. So then we are off the record in that case. And we're going to move on to a few more cases that we're hearing yet again. This is number 4 on the docket, Coterra Energy 25826.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating.
Thank you, Ms. Bennett. I don't believe there's any other parties.
There are no other parties.
I know that you've submitted the requested information. It's been reviewed and taken under advisement.
Thank you very much.
All right, thank you. Let's move on to 5 on our docket. I guess there's a few cases here, 25773, 74, and 75.
Jackie McLean on behalf of Permian Resources.
And Ms. McLean, I don't believe there are any other parties entered on these 3 cases. I know that you have submitted the information requested. It's been reviewed. They're taken under advisement.
Thank you.
So we're off the record in those cases. Let's now go on to Mewbourne Oil 25663.
Good morning, Mr. Hearing Examiner and Technical Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Mewbourne Oil Company.
Good morning, Mr. Examiner. David Kermsey of Bradford Sayre representing PBEX. We're just making an entry of appearance, no objections.
Okay, thank you.
and good morning, Mr. Hearing Examiner Yaritza Pena on behalf of Conoco Oil Phillips, COG, Concha Oil and Gas, and Marathon Oil Permian, and we do not object in this case.
Okay, thank you. I'll go right ahead. Ms. Vance.
Thank you. Excuse me. So this case has been around for a while, as you know. We previously filed an application and then we filed an amended application that corrected just one little piece of the illegal land description. Sorry, it's been a long week. I know Ms. McLean feels like that as well. So in this case, Mewburn is requesting pooling and approval of an overlap. And and it's pooling the uncommitted interest in a 962.45 acre, more or less, non-standard horizontal well spacing unit. And honestly, I can't remember. I think that they filed separately for the NSP, but I'd have to double check. Anyway, so this is pooling the Bone Spring Formation underlying the northeast quarter of Section 35, the north half of Section 36, Township 18 South, Range 31 East, and that's in Eddy County, New Mexico, along with lots 1 and 2, and the east half, that was the corrected part, of the northwest quarter and the northeast quarter, and that is the north half equivalent of irregular Section 31 and the northwest quarter of Section 32, and that is Township 18 South, Range 32 East, and that's in Lee County. So we've got 2 counties there. And Mewburn seeks to initially dedicate this spacing unit to the initial lead belly 3532 Federal Com 521H, 622H, 523H, and 624H. And we have included all of the typical exhibits for our landman and our geologist. Our landman is Ariana Rodriguez, and our geologist is Charles Crosby, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. Following that is my self-affirmed statement of notice, along with a sample copy of the notice letter, the amended application included in there that went out on November 18th, 2025, along with our affidavits of notice of publication, which were timely and were published on November 23rd and then 29th, 2025 between those 2 different counties. And unless there are any questions, I would ask that this case and the exhibits be taken under advisement at this time.
Admitted without exception. Mr. McClure,
Mr. Hearing Examiner, I just have a quick question for Ms. Vance.
go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Vance, was there going to be additional documents that you need to file in this case?
Not right now. We will,
Okay, so
I can just expand on that briefly, is the parties are working towards a JOA, or Mewburn is working towards signing a JOA with several of the parties. So we want to move forward as is, but once an agreement is reached later on down the road, we of course would file a notice of removal of pooled parties as is required to inform the division.
Okay, but Mewburn is still asking the division to force pull Conoco, COG, Concho, and Marathon at this point?
Correct.
Okay, and your understanding of their withdrawal of objection was not dependent upon them being dropped as a pulled party?
No, it was not. That's a letter agreement between the parties, which is a private contract matter. And right now we're here for the pooling. And so as of right now, what's in the exhibits is how we would like to proceed.
Okay, no more questions, Mr. Hearing Examiner. Thank you, Ms. Vance.
All right,
Thank you.
Mr. McClure, can this case be taken under advisement?
I believe so, yes. Yes, we can.
All right. Thank you, Ms. Vance. Okay, let's move on. We're off the record in that case. We are now on to number 9 on the docket. This is Admiral Permian 25709. And it looks like, well, there's another case joined with it, but I don't think it's on today's docket.
Yes, Jackie McLean on behalf of Admiral Permian and for case number 25709. And case number 25708 is actually the one that is set for a contested hearing on February 26th.
Thank you.
And I think we have one entry of appearance as well.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart, and we are making an entry of appearance on behalf of Matador, and we are just monitoring.
Thank you.
Thank you. In this case, Admiral Permian seeks an order pulling all uncommitted interest in the Wolfcamp Formation underlying a 480-acre, more or less non-standard horizontal spacing unit comprised of the west half of Section 17 and the east half of Section 18, Township 23 South, Range 28 East in Eddy County. And this unit will be dedicated to the Crostio Estates fee unit wells. Exhibits were timely submitted for this case last week and include the land testimony and corresponding exhibits of Hunter Hall, who has previously testified before the division and has been recognized as an expert in petroleum land matters, and the geology testimony and corresponding exhibits of William Carroll, who has not previously testified before the division. And if there are any questions, we'd ask that he be admitted as an expert in petroleum geology matters, and he would be available for any questions on the call. Finally, we included our notice testimony along with copies of the notice letter, which was sent to all parties on October 22nd and December 31st, 2025, along with an affidavit of publication from October 30th, 2025. With that, I ask that the exhibits be admitted for case number 25709 and the case be taken under advisement.
Admitted without exception. Mr. McClure?
Thank you, Mr. Hearing Examiner. I'll have questions for the landman in this case.
Okay, Hunter Hall. And he has already been admitted as an expert.
Perfect. Okay, Mr. Hall, please raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, sir. You have previously been admitted before this division as an expert in what field?
Petroleum land matters.
Perfect. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Hall, it appears that Admiral is asking the division for an NSP in this case. Is that correct?
Yes.
And there's reference in your self-affirmed statement to the reason for that being common facilities, or to make a common facility. Is that correct?
Yes.
Okay, looking at your 401H well, looks like it's a U well that's in both section 7 and section 8. Are you familiar with what I'm referring to?
I am.
The standard spacing unit for that well would be the east half of section 7 and the west half of section 8. Do you agree with that?
I believe so, yes.
Okay, so when you reference common facilities, can you elaborate a little bit more on what you mean by that then?
Yes, so I think that if you look at the 421H plat, that
Mhm.
well U-turns in the opposite direction of the 401H, which goes into the west half of the east half of 18. And so because the orientation of the U-turn wells, the surface locations are both in the southeast of the southeast. So separate spacing units would imply extra facility costs. And so we're asking for the exception due to the orientation of the wells. Because I think if you independently looked at the 421, you would say the spacing unit should be the east half of 18 alone.
Are you aware that there's a existence of defining wells and then infill wells for the spacing units established by that defining well?
I am, and I think that the defining well would be, well, I believe that both of the wells would be within 330 of the section 7 and 8, or at least one of the sides of the U-turn would be within 330 of the 7 and 8 line, if I'm looking at them correctly. And so that would allow for us to pull both tracks into the 480 acre spacing unit.
I guess if maybe I can provide a little bit more context.
Sure.
If you were to use the 401H as a defining well, then your NSP is essentially reducing the acreage of that standard HSU because you're now removing the east half of the west half of section
7.
Yeah, section 7. Okay, I'm with you. So I guess my question is, you reference common facilities, but I'm not sure how the difference in the NSP versus not having NSP would make a difference to your facilities. So if you could elaborate on that, or maybe provide reasoning for why you want to reduce the acreage and take out that east half of the west half.
I guess I'm not fully understanding the question, since the spacing unit consists of the entire 480 acres. Are you saying that one of the wells, if the 401H was the defining well, that since it does not include the west half of the east half of section 18, is that what you're referencing?
Yeah, you kind of,
I'm just making sure I understand correctly.
yeah, that's fine. I was going to say, essentially the NSP that submitted to us is not really correct. And as you're not expanding the acreage, you're reducing the acreage. And so I'm trying to figure out what the reason is for the request to reduce the acreage. Your current standard HSU is the east half of the one section and the west half of the other section. And you want to reduce that by 160 acres. Why is that?
If I'm understanding you, I guess I'm still not quite understanding your request. If
Can I ask a question?
Sure.
Mr. McClure, hold on one second.
Can I just add
McLean.
to better understand where
Go
was, I guess it's non-standard because we just want to have one spacing unit, not two separate proximity track spacing units, because they want that centralized facility and everything. Is that what you're asking? Or I guess am I confused?
Well, you're putting Mr. McClure in a difficult spot because he's not gonna answer questions. He can
Well-
ask questions.
Can you rephrase, I guess, can
Okay.
Mr. McClure, I guess, ask a question about why we would not want to proximity track spacing units.
Maybe Mr. McClure and I can talk offline for a minute
Okay,
and figure out what his concerns are, and then maybe I can help in some way.
okay,
So let's take a, I don't know, 5-minute recess.
okay, thank you.
All right, it is 9:26 a.m. We're back on the record. Mr. McClure, your questions for Mr. Hall?
Thank you, Mr. Hearing Examiner. Mr. Hall, is there a relationship in the facilities planned for these wells and the case that is contested? Presumably the Bone Spring wells, I guess.
Potential, if Admiral were to be the operator of the Bone Spring in a similar spacing unit, yes, that is possible. However, one of the things that Ms. McLean and I were discussing as to your original question is if you look at the offset operator exhibit.
Should I share the?
We're going to
Sure,
share.
or I can.
Okay, yeah, that's fine. If he wants, I can share.
Okay.
Give me 1 second. Oh, it looks like you already did it.
One of the points of emphasis we were discussing is that if two spacing units were created, being two 320-acre spacing units, we do not own east of the west half of the west half of 17, nor do we own west in the west half of 18. And so the original intent of putting on the application that we will have combined facilities, and that's why we're asking for an NSP, is that we are deviating the lands, be it's 160 less acres like you specified, but that they would be in a common facility in the southeast of 18. And that's why only, one of the U-turn wells technically only includes 160 more acres, not 320 more acres.
What is the standard spacing unit for the 401H?
I believe the 401H is the well that's independently just in the east half of section 18. Or no, the 401H is the well that deviates the east half of 18 and the west half of 17. So absent another well, the standard spacing unit would be those 320 acres. But our request is based off the 421H, deviating the west half of the east half of 18, in addition to the east half of 18. And then the common facility being in the southeast of 18.
Okay, moving on, I guess, from the reason for NSP question topic. Reference in the table or the map that you were just showing, the one that has the affected persons for the NSP request. I believe it's
Yes.
the exhibit A2, page 14 of 78.
Correct.
The operator in the east half of the west half, who is that?
It is Oxy. Of 17?
Of 17.
Yes, that is Oxy.
Was Occidental provided notice of this application?
They were.
Can you direct me to where that's indicated?
Yes. I'm gonna scroll down.
We sent notice. I can
Jackie, if
provide
you get
the
to it, if
page.
you get to it first,
Um,
yeah.
The receipt.
Hold on. We can't have two people talking at once because the transcript won't pick it up. So, Mr. Hall, before I go to Ms. McLean, what did you just say?
I was just indicating if Jackie finds it first in our notices.
Okay,
I was
so Ms.
scrolling down.
McLean.
Yes, we sent out the notices and there's a receipt on page 71 of the application packet that shows that it was delivered to Oxy.
As this is Ms. McLean's a part of the exhibit, Mr. Hearing Examiner, do you want me to ask her questions about it now or hold off till I'm finished asking questions of Mr. Hall?
Let's hold off until you finish with Mr. Hall.
Mr. Hall, what is the address, the mailing address that you have listed for Occidental?
I think on the pulled party list, it's PO Box 4294. But I think the proposal letters and communications we've had with Oxy have been an address in Houston, and then the correspondence that we've had with them.
Do you know if the operational staffs of Occidental Petroleum Corporation and Oxy are the same people?
I would assume so, yes. We've had conversations with Oxy as to potentially signing a JOA and plans of the development and the hearing.
Do you believe that Occidental Petroleum Corporation was provided notice at this address that you have listed in regards to the NSP?
Yes.
If I can direct your attention to exhibit A3, I believe it's page 23 of 78.
Okay. I'm there.
Do you see the table that's at like the bottom of that page 23 that's titled, well, the Estates Unit Wolfcamp Pooled Parties?
I do.
Do you see where only some of those persons are highlighted yellow and some of those persons are not? Do you see what I'm referring to?
I do.
Is Admiral asking the division to force pull only the highlighted persons or all the persons on that list?
Yeah, good clarifying question. At the bottom of the table, I highlight a separate cell that says parties seeking to pull. We are seeking to pull only the parties highlighted in yellow.
Okay, so then the title of that table is not accurate then, is that correct?
I would say it is if you take into account the end of the table being that parties seeking to pull are those that are highlighted on page 24 or yeah. Being that it's clear that we're only seeking to pull the highlighted parties, which I've done on other exhibits before.
See, I'm looking at your exhibit A-7, page 42 of 78. Let me get there myself. This is your commitment table. Are you
Yes,
there
sir.
as
I'm
well,
there.
Mr. Hall?
I am.
Okay, you reference towards the bottom of that, you reference Anthracite Energy Partners and Traverse Exploration LLC as being committed. Do you see where I'm referring to?
I do.
Under what agreement is Admiral considering them to being committed?
JOA and a well proposal election.
Okay, so then those persons have signed a JOA. Is that correct?
Correct.
So do you see on this table where you reference it says executed election?
I do.
Is that either not correct or not the complete story then?
No, we have executed elections and JOAs. And then the difference being with, say, Marathon or COG is we are negotiating with them in good faith right now. And so we put them as committed, but they're not on the pooled party list for that reason.
Okay, do you see towards the top of this table where you have several persons that's executed election plus JOA?
I do. It's just an error at the bottom. Anthracite and Traverse have executed the JOA.
Okay. If I were to ask you to correct this table, do you understand what I'm asking for?
I do.
Was Marathon and COG provided notice of this application?
They were.
I guess if I max, you may back up because I should have asked you this question. In regards to your Wolfcamp pooled parties table in your Exhibit A3, do you know what I'm referring to?
I do.
If I were to ask you to correct that or to change that title to be less questionable as to whether it implies that that entire table is being pulled. Do you understand what I'm asking for?
I do. Yeah, we can make those corrections.
What would your proposed new title be for that table?
Frankly, to make it easier, we can only list the parties being pulled. So the parties not being pulled, we can just take off. And so it's very clear that only the parties listed. It just won't, naturally, it won't add up to one since other working interest owners have elected and signed the JOA.
I think, so I think we can, do we need to commit to a name at this moment? Because I think part of it is that this is the unit recapitulation. So we just can't take everyone off on the top one, and then the bottom one, are we talking about this bottom smaller table, Crosco Estates Unit dash Wolfcamp Pulled Parties that has all the tract ownerships?
Yep.
I think we can just call it Crosco Estates Unit Wolfcamp. Period. We'll take off parties.
Yeah, Mr. Hall, I'm in agreement with Ms. McLean that we need to leave them all in there. At least I think that's what she was saying. But we just need to change the title to, get rid of pooled or get rid of pooled parties, something along those lines.
Okay, we can make that adjustment. And then you would like the same adjustment made to the table, the committed working interest owners table for those that have executed the JOA.
Yeah, I'm going to need the commitment table to be amended to now properly reflect the commitment for every person, especially Anthracite Energy Partners needs to be corrected.
Okay.
Mr. Hearing Examiner, I have no more questions for Mr. Hall, but I do have some questions for Ms. McLean.
Okay, go right ahead.
Ms. McLean, if I can draw your attention to your notice spreadsheet, page 57, maybe. Let me get there.
Okay.
Well, I don't think it's page 57. It's
the one that Oxy's on.
Yes, ma'am.
It's page 60 of the packet.
Oh, actually, your address isn't there. If you can direct my attention to the page with the
with the address.
Yeah,
Yes.
I'm scrolling down through.
I think it was 70 something. 72. 71.
Okay, I'm with you as well. Would you agree that this address is not the same as the address provided in the NSP portion of this application for Occidental?
Yes, I think that they had a PO box there, but we regularly send mail to Occidental and Oxy at this address in Houston, 5 Greenway Plaza. I have it memorized at this point. It's widely known as their address where they accept mail for all of these cases. So we could change it on his exhibit to reflect this one, but we know for sure that this is the Oxy/Occidental address. And they sign, and oftentimes we do change them because we know that there's a typo in someone's address or whatever it is. But I think that we could the address on that exhibit with the NSP plat is not really material to the fact that they've been named as the offset operator and that we provided them notice of this application.
Thank you, Ms. McLean. Do you have a list of the amended exhibits that we're going to need to be submitted?
Yes, I believe changing the Wolfcamp pooled parties table on exhibit A3 and then on exhibit A7, adding plus JOA to those two committed parties. And I'd ask that since these are essentially typos, we be allowed to submit them today so that the case be taken under advisement.
I'm gonna leave that up to Mr. McClure.
Thank you, Ms. McLean. Mr. Hearing Examiner, I would like them to continue the case for me to review those changes.
Okay, perfect. Freya, when is the next docket we could put this case on?
We could potentially add it to the February 26th docket so that it would pair up with its companion case that's set for contested hearing,
Okay,
or we could do March 5th.
I'm okay with February 26th, Ms. McClure.
I think that sounds
Perfect.
fine.
Okay, we're off the record in this case. Thank you,
Thank
Mr.
you.
McClure. Okay, let me just make some notes here. Okay, let's move on to case number 10 on our docket, 25747 Avant Operating.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating, and we'd like to consolidate this case with case number 25748.
I know you would. I'm
Oh.
calling this case separately for a reason. And that is once we accept your exhibits into evidence, we can take it under advisement. The other, we're gonna have questions on, so let's just deal with this as quickly as we can.
Yes,
Get
let's.
Go ahead, Ms. Bennett.
Mr. Hearing Examiner, Yaritza Pena, on behalf of Permian Resources Operating, just monitoring this
Thank you, Ms.
case.
Pena.
And also Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian, just monitoring.
Thank you, Ms. Vance.
And Caitlin Luck also entered an appearance in these cases on behalf of WR Non-Op.
Okay,
I'm not sure if she's on today, but she did not have any objections to the cases
Okay,
proceeding by
thank you.
affidavit.
go right ahead.
Thank you. In case 25747, Avant Operating 2 seeks an order pooling all uncommitted interests in a Bone Spring spacing unit comprised of the west half of sections 10, 15, and 22. And in support of this application, we've submitted the usual suite of exhibits, including the compulsory pooling checklist, self-affirmed declaration of Tiffany Sarantinos, who's previously testified before the division and her credentials have been accepted as a matter of record, self-affirmed declaration of John Harper, geologist for Avant, who's already been accepted as an expert in geology by this division, and my declaration regarding notice, which shows that notice was timely mailed and timely published. And with that, I would ask that the exhibits in case number 25747 be admitted into the record and the case be taken under advisement.
Admitted and taken under advisement. Let's move on now to case number 11 on our docket. That is 25748.
Good morning, Mr. Examiner. Dina Bennett on behalf of Avant Operating 2 LLC.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian, and we are just monitoring.
Thank you.
Good morning, Mr. Hearing Examiner, Yaritza Pena, on behalf of Permian Resources Operating, and we are also just monitoring.
Thank you. And I know Ms. Luck entered an appearance, but she's not here, so go right ahead.
Thank you. In this case, which is a companion case to the one I just presented, Avant Operating 2 is seeking to pool uncommitted mineral interests in a Wolfcamp spacing unit comprised of the west half of sections 10, 15, and 22, Township 20 South, Range 32 East. In this case, Avant is seeking approval of a non-standard spacing unit, and we've included information about that in Ms. Sarantinos's declaration. And so we've included the usual suite of exhibits, and as I just mentioned, both of the witnesses have previously been qualified and their credentials have been accepted as a matter of record. So without any further ado, I would ask that the exhibits in case number 25748 be admitted into the record. And if there's any questions I can ask, or answer for Mr. McClure, I'm happy to do so. But Ms. Sarantinos and Mr. Harper, I believe, are both on the line.
Perfect. Thank you. Admitted without exception. Mr. McClure?
Mr. Hearing Examiner, I'll have questions for the geologist.
Very good. Would you call your geologist?
Yes, John Harper. And Mr. Harper, if you don't mind turning your camera on, that would be fantastic.
And his mic is muted as well.
And Mr. Harper, your mic is muted as well.
I'll give him another few seconds. If he doesn't appear, then we can come back to this case in a few minutes, once we get another case out of the way. All right, let's move on to EOG Resources, 25760 and 25761.
Good morning, Mr. Examiner, Dina Bennett on behalf of EOG Resources.
Thank you.
There are no other parties that have entered into
Go right
appearance.
ahead, Ms. Bennett.
In these companion cases, EOG seeks to pool uncommitted interests in the east half of sections 13 and 24, Township 25 South, Range 33 East. And these are companion cases. One case seeks to pool interest in the upper Bone Spring and one in the lower Bone Spring. In the materials, we've included the compulsory pooling checklist and the self-affirmed declaration of James Barwis, who is a land professional for EOG. He's not previously testified before the division and his credentials have not been accepted as a matter of record. And I know the division's preference is generally to not qualify experts if there's no questions for them, but Mr. Barwis is going to be appearing before the division rather routinely going forward. And so I would ask that if time permits, that the division consider admitting him. The next exhibit is the self-affirmed declaration of Hannah Durkee, a geologist for EOG, and she has not previously testified before the division either. And so if the division does not have questions for her, I would ask the same latitude to have her qualified as an expert. And then finally, my self-affirmed declaration regarding notice, showing that notice was timely mailed and published. And also my firm took this case over from Holland and Hart, and Holland and Hart did some initial notice. And so we've included that as well. So I leave it up to the division's discretion, of course, in terms of timing about whether to qualify the two witnesses, but I would ask that the exhibits in case numbers 25760 and 25761 be admitted into the record and the cases be taken under advisement.
Thank you. They're admitted without exception. You didn't mention whether the notice was timely.
The notice was timely. My notice was timely mailed on January 12th and timely published on January 16th. And Holland and Hart's notice was prepared well before then.
Perfect. Thank you, Ms. Bennett. Okay, Mr. McClure, do you have questions in this case?
Mr. Hearing Examiner, I'll have questions for both witnesses in this case.
Okay, let's get them both on the screen.
Thank you. And would you like to swear them in at the same time? So Mr. Barwis and Ms. Durkee, if you can both turn your cameras on and your mics on. Right here.
Can you hear me?
Yes, thank you.
Would you both raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, I heard yes from both. You can put your hands down. Let's start with you, Mr. Barwis. Spell your name, please.
James. Last name Barwis.
Okay, and what expertise do you want us to recognize you as an expert?
Well, I started my career. I've got a degree in professional resource management, and that degree covers everything from the basic principles of land work, oil and gas law, water law, surface rights, mineral rights, mapping, GIS, environmental and oil and gas economics. And then when I started my career, I worked for a couple of land brokers, and that work consisted of negotiating right-of-way, surface agreements in North Dakota and Texas. I also did some mineral work for these land brokers. That was running title in various courthouses. That's preparing run sheets and mineral ownership reports for different clients. And then I've been with EOG since 2014. And during that time, I've worked all over Lee and Eddy County for, where EOG has leasehold in those areas. And everything I've done for EOG thus far has been a lot of different things: right away, surface applications, approval procedures with the BLM and state lands as far as doing pipeline right-of-ways, roads, well pads, staking wells with the BLM. I've also negotiated right-of-way surface use agreements with private landowners, follow a drill schedule, coordinate with the team members on lease and unit ownership for various well packages, provide ownership and lease information to help with the planning of wells. So just providing working interests, net revenue interests, lease burdens, lease critical dates, lease provisions. I also
All right,
do.
Mr. Barwis, I understand. Mr. Barwis, I'm going to interpret that answer as meaning you want to be considered an expert in petroleum land matters. Is that right?
Yes, sir.
Okay. From here on in, you are considered an expert in petroleum land matters. Let's get to you, Ms. Durkee. Spell your name.
HANNAHDURKEE.
Okay. And what field of expertise do you want to be considered an expert?
I'd like to be considered an expert in petroleum geology. I've been at EOG for over 10 years.
Can you start with your education that goes
Yeah.
toward that expertise?
Yes, sir. I have a Master's of Science Petroleum Geology from the Colorado School of Mines, and then a Bachelor of Science in Geology and Geophysics with honors and a minor in Business Administration from University of Utah from 2013.
Okay, perfect. And since 2013, what work have you done toward geology?
Yeah, since 2013, I've, like I said, done my master's at Colorado School of Mines and 2 internships with EOG, one in Denver, one in Oklahoma City, and then I started full-time with EOG in 2016.
What's your title?
I'm a geological specialist.
And what does that mean? What do you do?
So right now, so you start off as a Geo1, Geo2 senior, and then geological specialist is the next level above that. Over time, I've worked in 3 different divisions. I've worked in Denver and Fort Worth, and now here in Midland. In the last couple of years, I've been operating the Red Hills acreage development area, evaluating logs, tying core and subsurface data to production to determine our optimal development spacing, drilled hundreds of wells out here, proposing packages to management, and attended conferences to also discuss the depositional settings of a lot of our different targets in the Bone Spring and the Wolfcamp.
All right. Thank you, Ms. Durkee. From here on in, you're recognized as an expert in petroleum geology. Mr. McClure, who do you want to question first?
Mr. Hearing Examiner, Mr. Barris is fine.
Great. Go right ahead.
Thank you, Mr. Hearing Examiner. Mr. Barris, is it correct that EOG is requesting operating supervision costs of $2,000 per month per well?
Yes.
What is the basis for EOG requesting that value?
That is the average cost that we use for all of our joint operating agreements that we do with the non-op partners.
So then is the JOAs that were signed for this case, those were all at $2,000 per well per month. Is that correct?
I'll have to double check that, but yes, that should be correct.
Do other operators also charge $2,000 per well per month for operating?
That I could not answer. I'm not sure what other operators do. This is just our standard that we use here at EOG.
If I were to ask for additional supporting information, what would you propose to provide to the division to demonstrate that 2,000 is a reasonable cost?
Depends on the additional information that you're seeking as far as to provide you.
If I were to ask for something beyond just a simple statement, and as provide us with some additional data, what would you propose would be the most efficient manner of demonstrating $2,000 is reasonable?
I guess it sounds to me like you want maybe some sort of like a breakdown of what comes to that, of how we get to that particular cost. Is that what you're wanting?
Would you also have just some sort of, don't necessarily get into the nitty gritty of each separate proposed unit, but something along the lines that demonstrates that EOG is commonly requesting this and receiving this in their approved JLAs or executed JLAs?
Okay, just to see that that's like a showing the other JOAs that show the same cost structure.
Something along those lines, essentially to provide a little bit more context. To my knowledge, I think $1,400 per well per month has been kind of the highest of what the division's been commonly approving. And
Okay.
we're jumping drastically from $1,400 to $2,000 in a single jump here. I need some sort of indication to demonstrate that that is in fact reasonable costs, despite the fact that numerous other cases being heard before today is asking for $1,000, $1,200, $1,400. Do you understand, I guess, what I'm looking for?
Yes, I do.
Okay, thank you, Mr. Boris. Miss Durkee, hopefully I'm pronouncing your last name correct. Is that correct?
That is correct, yes.
Okay, thank you, Miss Durkee. Thank you, Mr. Boris, by the way. I don't have no more questions for you.
Okay.
Miss Durkee, if I can draw your attention to your maybe start with the gun barrel, exhibit B4, page 51 of 94, I think.
Sure.
Okay, I'm seeing all your 200 series of wells and your 300 series of wells. They're kind of towards the top of your gun barrel. Are you seeing where I'm looking at?
Yes, sir.
Now I see like indication on the left on your, I guess, depth scale where you have like the Leonard A and the Leonard B, and then the first Bone Spring, I assume sand. Do you see where I'm referring to?
Yes.
Okay, where does the first Bone Spring sand, the top of it, hit at across this table or this gun barrel diagram?
It would be at about 10,250 TBD-ish. Kind of right in the middle where those 311 wells are, right above the 311 wells.
Okay, so then is it accurate to say that the 200 series wells are above the top of the first Bone Spring sand?
Correct, yes.
Okay. If I were to ask for you to like draw some sort of line across there where the first Bone Spring sand top is, do you understand what I'm asking for?
Yes. I would put it between the two, like the 221 and the 311, just right in between there.
I guess I don't even see your 221. Where are you referring to by 221?
We're looking at the gun barrel diagram, correct?
Yes, ma'am.
There's the 200, just the 200 wells and the 300 wells. It'd be just right in between those lower 200 wells. Or are you looking at? Sorry, go ahead.
I guess what I'm looking at is some sort of like this horizontal line across the gun barrel diagram that depicts the top of the first Bone Spring sand. You understand what I'm referring to?
Yes, you'd like that as a follow-up? Or just to specialize where it is?
Yeah, I'll be asking for an amended exhibit packet, and my question to you is, do you understand, if I ask for that to be depicted there, do you understand what I'm asking for?
Yes.
Okay. I'm just looking at your cross section here. Hmm. No, I think the gun barrel should be enough. Thank you, Ms. Durkee. Thank you, Mr. Hearing Examiner. I don't have any more questions for the witness, but perhaps guidance for Ms. Bennett.
Okay, go ahead.
Ms. Bennett, do you have a list of what I'm looking for?
I do, and just as an update, Mr. McClure, I've coordinated with EOG, and they're willing to change the exhibits to reflect a $1,400 per month supervision fee, if that's in line with what the division is seeing. That may be easier than submitting another exhibit. So that's what they're, if that's agreeable to the division, I would update the compulsory pooling checklist to reflect $1,400 a month. And I would also get amended cross sections that add a line between the 200 series wells and the 300 series wells to provide as a revised exhibit packet.
Ms. Bennett, that should be sufficient. And in all realities, considering the amount of interest that's being pulled, I could definitely see where that might be the desirable outcome, I guess. And as is the minute amount being pulled here. Is your thoughts, I'm wondering about the landman self-affirmed statement, whether you believe that should also be amended to reference the $1,400?
I can amend that as well.
Okay, so then you're submitting me a new CPAC and landman statement changing the operating supervision costs and a gun barrel diagram. Is that correct?
Yes, for each case.
Okay, and when you resubmit, oh yes, for each case, when you resubmit, are you going to give me a digital exhibit packet rather than a scanned one?
You mean prepare it as a PDF rather than scan it?
Yes. And it was
That would be-
difficult. It was difficult for him to review.
I will try to do that. I'll do my best. At least every bit that I can just compile into a PDF, I will, as opposed to scanning it.
Perfect. Thank you.
Thank you, Ms. Bennett. Thank you, Mr. Hearing Examiner. I have nothing further for either of these cases.
All right. Thank you, Mr. McClure.
Oh, Mr. Hearing Examiner, can we come back on February 26th for this?
I was thinking about that before you said it. The docket on the 26th is starting to get large, especially with Ms. Shaheen's contested case. We have another contested case. We have 2 lengthy NOVs for environmental and non-compliance. I'd rather not put anything more on that docket at this point. I only allowed Ms. McLean to put her case on there because it's a companion case to another case we actually are hearing that day. So I'd prefer to have anything that we're going to continue, and there's going to be more to go to the March 6th, because if I start saying yes, we're going to have 20 cases added. So I'd rather have it on the March 4 docket.
March 5th.
Oh, I thought it was March 4. Okay, Freya, what is it? March 4 or 5?
5.
Thank you. Yes, Ms. Bennett, March 5th. Thank you.
Thank you.
All right, thank you. We're off the record in those 2 cases. Let's move on to Mewbourne Oil, 2 cases, 25776, 25777.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Mewbourne.
Good morning.
There are no other parties.
Go right ahead.
Thank you. In case number 25776, Mewbourne seeks an order pooling uncommitted interest in the Bone Spring underlying a 400-acre standard horizontal unit comprised of the south half of sections 33 and 34 and the south half southwest quarter of section 35, township 21 south, range 26 east in Eddy County. And that unit will be dedicated to the Buffalo Nickel 3335 State Comp 527H well. In case number 25777, Mewbourne seeks an order pooling uncommitted interest in the Wolf Camp underlying an 800-acre standard horizontal unit comprised of the south half of sections 33 and 34 and the southwest quarter of section 35, township 21 south, range 26 east in Eddy County. That unit will be dedicated to the Buffalo Nickel 3335 Statecom 716 and 718H wells. Our exhibits include the land testimony and exhibits of Braxton Blanford, who has previously testified before the division and been recognized as an expert in petroleum land matters. Our exhibits also include the geology testimony and exhibits of Charles Crosby, who has previously testified before the division as an expert in geology. Finally, our notice information is included and shows we timely provided notice to all interested parties on September 10th of 2025, and then again to certain parties on January 9th, 2026. And we did not publish notice in these cases because the party we notified actually just received the certified mail. So with that, I ask that the exhibits be admitted for these cases and that they be taken under advisement.
Thank you. The admitted without exception. I didn't catch, were both of your witnesses previously qualified?
Yes.
They were both.
Yes,
Okay, thank you. All right, Mr. McClure, questions?
Mr. Hearing Examiner, I have questions for the landman.
Let's call the landman.
Mr. Blanford. See if he is.
Can you hear me? Can you hear me?
Yes, we can hear you. We can see you now as well.
Okay.
Thank you.
All right, would you raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
All right, spell your name for the record.
Braxton, Braxton, Blanford, Blandford.
Okay, and I've worked with you before. I recognize you. So I don't have to ask you the questions I normally would. Mr. McClure, go right ahead.
Thank you, Mr. Hearing Examiner. Mr. Blanford, if I can direct your attention to your ownership commitment exhibit, should be exhibit A-6 on page 21 of 32.
Okay.
You see kind of towards the top of that table where you have Civitas DE Basin Resources LLC listed as not committed.
Yes.
Is this still accurate?
At this time it is, as it says in the type of commitment in the next column over, we're working on a JOA together, still at this time, but that is accurate at this time.
Do you believe that Civitas was provided notice of this application?
I believe they were, but they're not listed as a party that we're pooling on this application. Partially just because I believe they were apprised of the proposals a little later. So
I thank you, Mr. Blanford. Mr. Hearing Examiner, I have no more questions for the landman, but I do have some questions for Ms. Hardy in regards to notice.
Go right ahead.
Ms. Hardy, do you believe Civitas was provided notice of this application?
I don't believe they were provided notice. They were in communication with Mr. Blanford, and they have been, but they're not being pooled. So don't believe we had to notify a party that's not being pooled.
Now, Mr. Hearing Examiner, do you want us to have a discussion about the required noticed parties for compulsory pooling, or what's your thoughts here, I guess?
I think at this point, being that we need to break around 11:30 today and then come back on the record after lunch, I'd rather keep the discussions to a minimum. If there's something that you want from Ms. Hardy, please just tell her, and we'll come back on the record at a future time and deal with that notice.
Okay, sounds good. Ms. Hardy, before the division could approve this case, Civitas will need to be provided notice of the case. As to whether we dismiss the case and require you to refile or continue it to allow notice to be cured is in our hearing examiner's discretion there, I guess. But one way or the other, they will need to be provided notice.
Well, I think we're happy to provide notice. I would respectfully request the case not be dismissed. That seems like a costly and time-intensive waste of resources for everyone involved.
Okay,
So-
so Ms. Hardy, how do you plan on proceeding?
I would expect that, well, I would ask that we could continue this case to the March 5th docket, and then we'll have time to send Civitas notice. And it's also possible that they've signed a JOA by then, and so we just remove them as a pooled party.
Perfect. Okay, and if you do remove them as a pool party, but then you'd amend one of your exhibits as well?
Correct.
All right, perfect.
Yes.
That sounds fine with me, Ms. Hardy. Anything else, Mr. McClure, on this case?
Yes, Mr. Examiner, I do have some further guidance for Ms. Hardy.
Okay, go right ahead.
Ms. Hardy, if I can draw your attention to your CPAC for case 25776.
Yes.
Let me get there my own self. The pool that you have listed here is incorrect. Do you have a pen and paper or something handy that give you the new pool code or the correct pool code?
I do.
The correct pool is the Esperanza Bone Spring, pool number 97755.
97755.
That is correct, Ms. Hardy.
Okay.
Let me look at your Form C-102 real fast. I don't know if I wrote a note about whether we need one of those or not. Yeah, Ms. Hardy, appears the Form C-102 also has the incorrect pool. So if we can provide an amended CPAC and an amended Form C-102 to show the correct pool.
We will do that. Thank you.
Yeah, thank you, Ms. Hardy. Thank you, Ms. Hearing Examiner. Nothing further for these cases.
All right, we're off the record, and these cases will come back on March the 5th.
And Mr. Hearing Examiner,
Yes.
the Avant witness
Perfect.
is ready.
I'm gonna ask you
Okay,
that.
thank you.
Okay, let's recall 25748, and who is your witness?
Thank you. It's Mr. John Harper, and he is in the office with Sophia Guerra, so it might show up as SG.
Perfect. And remind me, Mr. Harper has been qualified previously?
He has, yes,
In what field?
in the field of geology.
Okay, perfect. As soon as there we go. Mr. Harper, please raise your right hand. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay, you can lower your hand. Would you spell your name?
John Harper, John, last name Harper, Harper.
Okay. Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Harper, getting your exhibit packets opened up again now. I'm looking at your exhibit B6, page 77 of 94. This should be showing your cross section for what you're dubbing the Wolfcamp D wells.
Yes, sir. I see it.
Okay, on this cross section, you see where the top of the strawn is depicted?
Yes, sir.
Where is the top of the Cisco Canyon formations?
You know, that's a great question. You know, the Cisco Canyon is more of a shelfal, northwest shelfal nomenclature, is at least historically speaking. Whereas in the basin, the Wolfcampian is more of the section that sits directly upon the strawn. It's just kind of a nomenclature dispute between basin and shelfal.
What is the age of disposition for the Wolfcamp D, as you're dubbing them?
Lower Wolfcamp, without any kind of, biostrap markers or any kind of data range. It's hard for me to give an exact age, but it's younger than the strawn.
Would it be accurate to say that it was laid during the Pennsylvanian era?
You could argue that.
Okay, where on this cross section would the top of the Wolfcamp D or Pennsylvanian occur?
Again, it's a little convoluted as the lower Wolfcamp, the Wolfcamp B, C, and D is hard to define up in this neck of the woods, up in this northern part of the basin. A lot of geologists would pick the top of the Wolfcamp D different than I would pick the top of the Wolfcamp D and vice versa. But it'd be hard for me to put a Wolfcamp D top, but I would say maybe somewhere around 11.7 on the middle well, or the Laguna 16 State, or 11.8 TVD on the Sam Snotty well. Wolfcamp D.
So are you in agreement that the 800 series of wells is below that top?
Sorry, can you repeat that question?
Okay, do you see your dotted line there where you're referencing your 801 to 804 H wells?
Yes, sir.
Are you in agreement that that dotted line is below the top of the Wolfcamp D?
Yes, sir. What I would call the Wolfcamp D.
Are you aware of whether there's any upper pin wells in the vicinity?
I don't know of any horizontal upper pin wells within this vicinity. We have seen well proposals for Wolfcamp, the lower Wolfcamp wells targeting the similar or same interval from other operators in this vicinity. There are vertical Strawn wells in this near vicinity, but the other well proposals we've seen from other operators would suggest they would agree with Wolfcampian, at least Wolfcamp horizontals.
If I were to ask for this cross-section to be amended to include your pick for the top of the Wolfcamp D, do you understand what I'm asking for?
Yes. I can fill on the sub members of the Wolfcamp on this cross section. That's what you're asking.
Specifically, the Wolfcamp D is what I'm interested in, but you can include the others too. That's fine.
Okay. Yes, sir.
Thank you, sir. No more questions for the landman, Mr. Hearing Examiner, but I do have some questions for Ms. Bennett.
Go right ahead.
Ms. Bennett, I'm wondering if maybe you can take some time with your client. The Wolfcamp D is not a part of the Wolfcamp pool. And so I don't know if they may wish to remove those Wolfcamp, those 800 series wells from this particular compulsory pooling case, or if you'd like to add an additional pool, I guess, and we'll see what the approval process of that's going to be, I guess.
What, if you don't mind, what pool is the Wolfcamp D part of?
It would be part of an upper pin wildcat.
And is that a oil pool?
That's a good question. I've talked to my district geologist on that. It could potentially be gas. We'd have to look. We would probably take feedback from the applicant, though, as to whether they believe their wells, what their GOR of their wells would be my assumption there.
I will definitely confer with Avant about this, but I think my initial reaction is Avant's preference would be to amend the compulsory pooling checklist and the C-102s to reflect the Upper Penn Wildcat Pool and dismiss the wells out of this application that are not part of the Upper Penn Wildcat Pool. So we could dismiss the 700 series wells, leaving the 800 series wells, and just amend the compulsory pooling checklist and the C-102s to reflect the Upper Penn Wildcat Pool.
And see, I was actually picturing it the other way. In your application that went out, do you think it's representative of showing this Upper Penn production rather than Wolfcamp?
The application does identify the as it being Wolfcamp, but I think that that is consistent with it being perhaps Wolfcamp D formation, but Upper Penn Pool is what I hear you saying. That I don't hear you saying that you disagree that this is part of the Wolfcamp, but rather that it's not part of the Wolfcamp Pool. And so we did not include the pool or pool. Well, we did include a pool and pool code in our application, but that happens often when we include a pool and pool code, and it has to change at hearing. So that seems, what I'm suggesting seems consistent with the division's practice of allowing applicants to amend their compulsory pooling checklist and their C-102s to reflect the correct pool and pool code. And I seem to recall, and I can look for this, a similar situation that occurred with the Twinkle, I believe it was Twinkle wells, where the division allowed the applicant to dismiss certain wells and maintain other wells. It wasn't Twinkle, I'll remember the name later. And that's what we would be asking for here. But I can confer with the client and come back with you after on a break or after a break or something like that.
Yes, Ms. Bennett, that may be the most ideal, and also confer with them as to whether whether they would be amenable, I guess, to including whatever the series above. I don't know if they were series 700 or what they were. Yeah, I believe it's series 700 on this and dismissing the 800 instead, or what their thought process is there.
Yes, I'll confer with them and I'll get back to the division. If we were to dismiss the 800 series, then the 700 series application could be taken under advisement with could the 700 series be taken under advisement? And I don't mean to ask you a question, but just want to make sure I'm understanding my options.
Well, we're still going to need all our exhibits amended, so you're still going to have your continuance. But yes, if the 700 series, I would agree that would be fine to go with the 700 series once the exhibit packet is amended to reflect that.
Thank you. I will confer with Avant.
Thank you, Ms. Bennett. Mr. Hearing Examiner. I was in the wrong place. Yeah, we already took the companion case under advisement, I believe. Correct, Ms. Bennett?
Yes.
Okay. Thank you, Mr. Hearing Examiner. I have no further questions for this case at this point, I guess, till we come back.
Exactly.
If you're fine with us recessing, I guess.
Sure. Recessing? Yes, recessing. Ms. Bennett, March 5th? It may take longer.
I may have a suggestion that would mean that we may not have to come back. So I'd like to discuss that with Avant first.
Okay.
Before committing to March 5th. But if we have to come back, then yes, March 5th.
How would talking to Avant alleviate March 5th?
Well, if we're able to dismiss the 800 series cases, then any exhibits related to the 800 series cases or 800 series wells are just irrelevant and would not need to, the exhibit packet would not need to be amended. We could just say on the record that it's dismissing those wells from its application and from the case, and then we would not need to come back. And the division has done that before where it's allowed operators, applicants to dismiss wells at a hearing without requiring an amended exhibit packet.
What about the geology
Yes.
exhibit that
Mhm.
Mr. McClure was talking to your witness about?
Yes, sir.
About that formation in the upper pen?
That relates only to the 800 series wells that would be dismissed.
Mr. McClure, well, why don't we wait for you to talk to your
Yes.
client first?
Mhm.
And then before the day is over, because the day seems, I'm sure it's going to go into the afternoon. Why don't you let me know what your client wants to do? And then I'll find out from Mr. McClure if he does want any further review, even if you just dismiss wells.
Yes, I understand that. Thank you.
All right. So Mr. McClure, that'll be a question that we will still come back to decide. Okay. So I'm going to leave a note here to come back to this case.
Thank you.
All right, let's move on to Permian Resources, 25793, 25796.
Jackie McLean on behalf of Permian Resources.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating.
And your position.
We are not objecting.
Thank you.
Good morning, Mr. Hearing Officer Adam Rankin, appearing on behalf of EOG Resources, just appearing and monitoring the case.
Perfect. Thank you, Mr. Rankin. Okay, go right ahead, Ms. McLean.
Thank you. In case numbers 25793 and 25796, Permian Resources seeks an order pulling all uncommitted interest in the Bone Spring and Wolf Camp formations underlying a 640-acre, more or less, standard horizontal spacing unit comprised of the east half of Section 34, Township 19 South, Range 32 East, and the east half of Section 3, Township 20, Range 32 East in Lee County. And this unit will be dedicated to Colonel Freckles FedCom wells. Exhibits were timely submitted for these cases last week and include the land testimony and corresponding exhibits of Mark Haddock, who has previously testified before the division and has been recognized as an expert in petroleum land matters. We also have geology testimony exhibits from Christopher Canton, who has also previously testified as an expert geologist before the division. Finally, we include our notice testimony and exhibits, which shows that notice was timely sent to all interested parties on November 26, 2025, and we have an affidavit of publication for December 21st. And if there are questions, we're happy to answer those, but I ask that the exhibits be admitted for these cases and that the cases be taken under advisement.
Admitted without exception. Mr. McClure?
Thank you, Mr. Hearing Examiner. I'll have questions for both witnesses.
Did you call them?
Yes, Mr. Haddock and Mr. Canton.
Mark Haddock.
And is Chris Canton?
Yes, can you all see me?
Oh, there, okay.
All right, I can see both of you. Would you please raise your right hands? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, you can put your hands down. Would you, Mr. Haddock, would you please spell your name?
Mark, M-A-R-K, Haddock, H-A-J-D-I-K.
Thank you. And Mr. Canton?
Chris Canton, C-H-R-I-S-C-A-N-T-I-N.
Thank you. I recognize both of you. We've worked together before, and I know that you're both accepted as experts in your fields. Mr. McClure, who do you want to start with?
Thank you, Mr. Hearing Examiner. Mr. Haddock's fine.
Go right ahead.
Mr. Haddock, if I can draw your attention to your exhibit A-3. Specifically, I'm looking at page 17 of 48 for the Wolfcamp wells.
Are we on case number 25796 or 25793?
I'm on 796, but the exhibit should be pretty much the same, just different page number.
What was the page number again?
Maybe it'd be better if I describe. I'm looking at your list of record title owners that appears that you wish to force pull.
Okay.
Is it
And I will
correct?
share, I'm going to share this.
Are you with us, Mr. Haddock?
Yes, I'm here.
Mr. Haddock, is it true that does Permian wish the division to force pull those 5 record title owners that appear to be highlighted in the middle of that exhibit page?
Yes, those are for lessees of record with the BLM. They're not working interest owners. So they don't have any actual ownership in the wells, but they do have they are listed in the records of the BLM as still being lessees of record.
Is Permian requesting the division to force pull them?
Correct.
Were all those persons provided notice of this application?
I believe so, yes.
I didn't understand the answer, Mr. Haddock.
I said, yes, I believe so. I would have to.
I see. So you didn't do the notice. It would be Miss McLean.
Yes.
They're looking, Mr. McClure.
Yeah, Mr. Herings, I was just going to come back to Ms. McLean at the end if you think that's most appropriate to ask about this as well.
I do, since it was Miss McLean who did the notice.
Thank you, Mr. Haddock. I don't have any more questions for you. Mr. Canton, if I could draw your attention to your Exhibit B4. I believe it's page 36 of 48.
Yes.
Okay, do you see the red line that's kind of towards the bottom of the cross section there?
Yes, sir. It's top of Strawn.
Okay, on this cross section, where would you place the top of the Pennsylvanian?
On a top, I typically pick, typically don't go that low. But the Strawn is just a really good marker because it's really easy top to pick. I would say, just somewhere between the Wolfcamp D and the top of Strawn would be in the pin there. But we typically don't drill deeper than where my line is for the Wolfcamp target.
Would you agree that your Wolfcamp target line, that purple line there, would you agree that that is within the Pennsylvanian aged rock?
I would say that's within the Wolfcamp, lower Wolfcamp.
How are you identifying the Wolfcamp D?
I have certain signatures that I look at, and just what our company, Permian Resources, what we call the Wolfcamp D.
Were you listening to the case a few minutes ago where I laid out that the division considers the Wolfcamp D to be part of the upper Pennsylvanian rather than a part of the Wolfcamp?
Yes, sir. I was.
Are you in disagreement that your Wolfcamp D, the top of that would be the top of the Pennsylvanian?
You could interpret it as that, but as Permian Resources, we show the Wolfcamp D to be there and kind of contiguous throughout the basin, and this is just how we pick it. As for where the pin actually sits, you would need to do some look at the rock and take core and see exactly where that is. But as for how we pick it standard, right here, where I have it picked on these 2 logs is where we pick the Wolfcamp D.
Now, earlier you referenced that you think the top of the Pennsylvanian aged rock may be below where you picked the Wolfcamp D, is that correct?
Yes, the pin would, yes, it's below the Wolfcamp, and after that is the Strawn, correct.
And where on this cross section is the two proposed wells going to be completed at?
On this cross section, so it's going to be where I have that purple line right there, give or take, 30 feet up or down of that line.
Thank you, Mr. Canton. Mr. Hearing Examiner, I don't have any more questions for the expert witnesses, but I do have questions for Ms. McLean.
Go right ahead.
Ms. McLean, have you had a chance to see if all the record title owners were provided notice of this application?
Yes, I believe that they were. They're all in the affidavit of publication, and it looks like what happened was some of the addresses were not populated in the table that's attached as Exhibit C1. But they're all in the affidavit of publication. We list all of the parties. We were investigating it. I thought that might be a question.
You want to come back with that answer?
That's the answer.
That's
the answer. Yes.
I thought you said
They
you
were
were
provided notice.
I thought you said we're
No,
investigating.
we were investigating because he had mentioned that.
Mr. McClure, does that satisfy you? Do you need something updated or changed?
I mean, we're definitely going to need the certified tracking numbers for each of these record title owners, assuming that the applicant still wishes the division to force pull them.
Can you provide that, Ms. McLean?
Yes, we can provide that.
Okay. What, is there anything else besides that you want, Mr.? Okay, go right ahead.
I think the geology.
Yeah, Miss McLean, I guess this is another one of those scenarios where I don't know if you need to touch base with your clients to see how they want to approach this. But from an initial look at this appears to be in a different pool, not the Wolfcamp, but the upper pin is the initial glance here. And maybe your client wishes to try to provide us some geological evidence, a wider cross section, something along those lines to demonstrate that this is not in the upper pin. And the division can review that. But if we decide differently, these cases would be denied, or this case would be denied, the Wolfcamp D case.
I think we'll definitely need to touch base. I would say at this point, can we just go ahead and say we'll continue these to March 5th? And then we'll make a decision between now and then, and we can notify the division.
Of course. That's what we'll do.
Okay, thank you.
Okay, are we done with these cases, Mr. McClure?
Just to confirm, Mr. Hearing Examiner, Ms. McLean, you were going to provide us the notice exhibits for both of these cases, correct?
Yes, we'll provide the tracking numbers, and then, but the more pressing issue seems to be this upper pin versus Wolfcamp formation that we need to discuss.
For one of the cases for sure, but the other
Yes,
cases
yeah.
dependent solely upon notice.
Right. Yeah, so
Okay.
we have those, we can provide them. I believe they just were not included on the table. Because everyone is there, but we just don't have the tracking numbers. we will get those together.
Thank you.
Okay, thank you, Ms. McLean. Thank you, Ms. Hearing Examiner.
All right, we're off the record in those two cases. Let's go to Coterra Energy, 25805, 25806.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating. And there is one other party, Mr. Randy Cohn.
Have you been in contact with him?
Coterra has been in contact with him and Coterra acquired his interest and he did not withdraw his appearance, but he did withdraw his objection.
In writing?
Yes, it was
Perfect.
provided to the division.
Okay, perfect. Go right ahead, Ms. Bennett.
Thank you. In these two cases, these are two companion cases. And in these two cases, Coterra is seeking to pool uncommitted interest owners in a Bone Spring and a Wolf Camp horizontal spacing unit, each of which covers the east half of sections 25 and 36, Township 19 South, Range 33 East in Lee County, New Mexico. And we've provided the usual suite of exhibits, including the compulsory pooling checklist, the self-affirmed statement of Ashley St. Pierre, who's previously testified before the division, the self-affirmed statement of Joshua Russo, a geologist for Coterra, who has not previously testified before the division, and then a self-affirmed statement by myself regarding notice, showing that notice was timely mailed on December 12th, and that publication was done timely on December 17th. Although I do have one update to that for case number 25806, which is that in case 25806, we inadvertently did not notify the offsetting tract owners for the non-standard unit portion of the application, and we inadvertently did not notify some of the overlapping spacing unit owners. And so we have done that now, but the notice would not be timely until February 26th. And I understand that February 26th may be out, but I would also just note that these cases involve lease expiration issues. So if there is any flexibility at all to come back on February 26th, I would certainly appreciate that. But I also understand that Mr. McClure may have other changes. So without further ado, I would ask that the exhibits in case number 25805 and 25806 be admitted into the record. And if the division has any questions, I'm happy to answer them. And so are our witnesses.
Thank you. Admitted without exception. Mr. McClure, who do you have questions for?
Mr. Hearing Examiner, it looks like I'll have questions for both witnesses.
Okay, let's get them on the screen. And you said one was previously qualified, one was not.
Yes. And just before we start the questioning, I did want to note that I have reviewed the geology exhibits, and there were a few changes that we need to make to the geology exhibits that Mr. McClure may be asking about. So just proactively, we are going to add well names and API numbers to the cross sections. And then there's a change that we need to make to Mr. Barwis's declaration. So, Mr. Russo.
Okay, thank you.
So yes, Ms. St. Pierre has previously been qualified and Mr. Russo has not.
I recognize. Thank you. Please raise your right hand, both of you. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Let's start with you, Ms. St. Pierre. Would you spell your name?
Ashley, ASHLEY, St. Pierre, ST period space PIERRE.
All right, thank you. And I recognize you as an expert in petroleum land matters. Thank you. Mr. Russo, spell your name, please.
JOSHUA RUSSO.
Okay, and you're seeking to be qualified in what field?
Petroleum geology.
Geology, excellent. Just briefly tell me your education and when you achieved your degrees.
Yes, sir. I received a bachelor degree of science in geology in 2009, and then also a master of science in geology in 2013.
From what school?
University of Texas System, Permian Basin, sir.
Both of them?
Yes, sir.
Okay, perfect. And since that time, what work have you done in the field of geology?
Yeah, so I've worked as a petroleum geologist in oil and gas since 2013, so nearly 13 years now. And throughout my career as a petroleum geologist, I've used a number of tools to evaluate the subsurface, multiple different development areas, depositional environments, generate maps and cross sections, understand potential development opportunities and executable development opportunities, using a variety of logs, mud logs, porosity logs, resistivity logs, petrophysical derived curves, offset well data, perf data, production data, IP data, etc. Worked on selecting drilling locations, target zones, planning developments. I would say over my career, I've drilled over 50 wells from planning through execution, and have recompleted over 130 in my past experiences.
All right. Thank you, Mr. Russo. What position do you hold with Matador?
So I'm with Coterra currently. I've been with Coterra for over a year now as a senior geologist working in North Lee and Eddy County.
Okay, perfect. Thank you very much. From here on in, you're qualified as a petroleum geologist. Thank you. Mr. McClure, who do you want to start with?
Thank you, Mr. Hearing Examiner. If I may, could I actually start with Ms. Bennett?
You can start with anyone you want. Go right ahead.
Hi, thank you, sir. Ms. Bennett, just to quickly clarify, you mentioned there were some changes made and you were referencing like the NSP. Was one of those changes made that the working interest owners in some of those offsetting tracks are going to be provided notice?
Thank you. Yes, in the offsetting tracks, we did not provide them notice yet. Well, I should rephrase that. I have now provided them notice as of Friday. But for purposes of the NSP, when I was preparing the exhibits, I realized that we had inadvertently not sent notice letters to the NSP offsets. And so we have done that now.
I guess what my question is related to is in the current exhibit, it looked like the operator was still identified for several of the offsetting tracks, whereas the working interest owners are going to be the ones that need to be provided notice. Does the new exhibit and new notice take that into account?
So for the offsetting tracks where Coterra is not the operator, we notified the operator, which is appropriate under the division's rules. For the tracks where Coterra is the operator, we notified the working interest owners.
And is that exhibit being updated to reflect the working interest owners rather than the operator?
Let me just take a quick look at the exhibit real fast and I'll be able to let you know that answer. If it's not reflected in the exhibit, then yes, I definitely will update it.
Okay, that answers my question, Ms. Bennett, because the one currently on file, I just thought maybe you meant there were new exhibits being submitted. That's not submitted to us yet, I guess. And,
right, and
I guess that does
now.
not include updated NSP. Is that correct?
That's right. I see that the map that is included only identifies the operators and does not identify the working interest owners. So we will add that as an updated exhibit.
Okay, and it sounds like you understand what I'm asking for. I don't need to talk to your expert witness. Is that correct?
That's right. And that's only for case 25806. I just want to be clear that that is only for 25806.
I'm in agreement.
Okay, thank you.
Ms. Bennett, another quick question before I go to the expert witnesses. In your exhibit, the only one it really matters for is the 25806. There's a printout of the text that would have been a part of that newspaper clipping. Are you familiar with what I'm referring to?
Yes, I am. And I can answer.
Can you verbally confirm for me that what you have printed out is in fact what was included in the newspaper clipping?
Yes, I can. The newspaper, despite repeated requests, did not provide a full copy of the affidavit of publication. And so what we did is we went on to the newspaper's website, and this is a copy of what was on the newspaper's website as showing what was published.
Okay, thank you.
Sorry, excuse me.
Thank you, Ms. Bennett. Ms. St. Pierre, Is it accurate that Katerra is requesting $2,000 per month per well for operating supervision?
Yes, that is accurate.
Do you believe that's a reasonable cost?
We feel it's reasonable because in this area, we have a little bit more regulatory burdens with the potash, the Capitan reef, and the dune sagebrush lizard. However, if the division feels that we need to alter it down to $1,400, we are amenable to that.
Well, I mean, it's up to Katerra what they wish to do. The only thing I'd lay out is if you wish to request the $2,000, then I would ask that you provide additional supporting documents demonstrating why $2,000 is reasonable. If you drop it to $1,400, then that's an accepted number that to be reasonable, I guess. So what does Katerra wish to do, I guess?
We will drop it down to $1,400.
Okay. Trying to see if I have more questions for you, Miss St. Pierre. I'm thinking maybe not. Thank you, Miss St. Pierre. Mr. Russell, if I can draw your attention to our Wolfcamp case, the 25805.
Yes, sir, Mr. McClure.
Let me actually get my exhibit packet open here. I have some questions in regards to this Wolfcamp D discussion that we've been having.
Sure.
And I'm looking at your Exhibit B6 on page 53 of 78 for the case 805. Are you with me, Mr. Russell?
Yes, sir, Mr. McClure, on page 53, Exhibit B6, and it's just for the record, Mr. Russo.
Oh, was I calling you Russell or something? Oh, Russo. I apologize, Mr. Russo.
Yeah,
I'm
no
saying it correctly now, right?
Yes, sir.
Thank you, Mr. Russo.
Yeah.
On this Exhibit B6, you see that box that you have identified as the target, kind of there in your middle cross-sec or your middle log?
Yes, I do.
And there's like a line that kind of goes across your cross-section, kind of directly below that arrow, and it's kind of in the middle of that target box. Do you see what I'm referring to?
Yes, I do.
What is that top, or what is that line representing?
That is our marker that we can correlate across this region throughout this zone that we follow, we track.
Is it your representation of the top of the Wolfcamp D?
So the nomenclature, I know company to company changes. I would say that is our, what we would call Cisco.
Okay, so is it accurate to say that's what you would consider the top of the Pennsylvanian then?
I would have to really look into that like the other guys that have been on this morning to determine that answer.
Now I see your blue arrow is higher than that line, but yet your target box includes all the way down to the top of the strawn. Where are these wells
Yeah,
And I'm not sure off the top of my head what series they are, but the series of wells, where are they going to be completed at?
yeah, so let me scroll up to my. They are going to be completed in and around that stratigraphic line that I have through the middle of the target, where that blue arrow is shown.
Okay, now you reference are you referring to the blue arrow or are you referring to the stratigraphic line that goes across the cross section?
Yeah, so the blue arrow is a general target line where it says target, and then where you see the blue arrow is where we're planting these wells.
Okay, so then would it be accurate to say that your target box might not actually include the entirety that you currently have depicted?
Yes, that's probably fair.
And that it may, but let me mute a phone caller. And it may be more accurate to say that your target box, at the very least, its base of it might be where that stratigraphic line is that you have. Would that be accurate to say?
Can you ask me that again, referring to the base of what?
Okay. Right now, you have the base of the target box at the top of the strawn, correct?
That's correct.
Yeah, just to make sure, I guess I understand your earlier answers, I guess. Would it be accurate, would it be more accurate for the bottom of that target zone to actually be at that stratigraphic line that you have depicted in your cross section?
Yes, I think we should have tightened up that dashed red box to specify the target more clearly.
Now, when I scroll up to your exhibit B2, this is on page 49 of 78.
Yes, sir, I'm there.
Yeah, and you see where you have like the two 700 series wells and the 800
Yes,
series
sir.
well.
Yes, sir.
And then you see there's like a strat.
Yes, sir.
There's like a strat line or something there on that left-hand log at like 11,870 or something. You see what I'm referring to?
Yes, sir.
What does that line
Yeah.
represent? Is that the same as the stratigraphic line on your cross section?
Yes. So yes, sir, it is.
Okay, so then would it be accurate to say that that 800 well may actually be below that strat column line?
Yes, sir.
Okay, but the 700 series line, that would be more equivalent to where the blue arrow is in the cross section. Is that accurate?
Yes.
If I were to ask you to conduct additional review and try to determine where the top of the Pennsylvanian aged rock is, do you understand what I'm asking for?
Yes, I do.
And specifically, I'm interested to know if those 700 series wells are going to be drilled above or below that line. So do you understand, I guess, my impetus on wanting to know how those relate to that review? Is that correct?
Yes.
Okay, but as of now, are you in agreement that the 800 well is drilled in the upper Pennsylvanian?
Yes, that would be fair.
Let me review my notes. Oh, then Mr. Russo, it sounded like Miss Bennett already talked about like adding the well names and API numbers and such to the cross sections. You're understanding what we're needing there?
Yes, sir. We've already supplied that as well.
Yeah, very good.
Yep.
Thank you, Mr. Russo. Miss Bennett, do you have a list of what we're needing for these cases?
I do. And I can run through it really quickly if you'd like me to.
It may be just to make sure we're on the same page, I guess. That may be ideal.
Okay, so for case 25806, which is the bone spring case, I need to add a notice parties exhibit for the NSP portion to show the working interest owners where Coterra is the operator. And then I need to revise the compulsory pooling checklist and the landman's declaration to reflect 1,400 per month for well supervision costs. And then for 25805, I will do the same thing to revise the compulsory pooling checklist and the landman's declaration to reflect $1,400 per month supervision costs. And then I will coordinate with the geologist to determine the best path forward with respect to exhibit B2 and B6 in terms of the need to revise the geology exhibits.
Yeah, we're going to need to revise them regardless for the well API and well name, of course.
Yes.
But if Coterra wishes to drop both its 700 and its 800 series wells, then I mean, we would no longer have the need, I guess, for the additional review for the upper pin. Is that kind of where your understanding is?
Well, yes, I mean, I think I would need to talk to Coterra and I'll do that on a break.
Yeah.
But if they are able to drop the 800 series wells and just move forward with the 700 series wells in this application without having to refile, that would be ideal because as I mentioned at the outset, there are lease expiration issues here and Coterra is trying to get an extension, but has as of yet not been able to get an extension of time. So they are under a bit of a push to get an order so that they can begin developing the acreage to save that lease or save the leases. So if there's anything we can do to allow at least one of the cases to move forward on an expedited fashion, that would be much appreciated.
I don't see a path forward there, but touching back on the 800 series well, if it's included, then your only path forward is going to be to include the additional upper pin pull wildcat in your compulsory pooling.
And if we only leave in the 400 series well, then that seems like that could be a path forward.
Yeah, if you only leave the 400 series wells, then I think we should be fine.
Okay.
I mean, we're still going to have to amend our exhibit packets.
Right.
But
I
as far
understand
as the additional geological review,
Mhm.
dropping both the 700s and the 800s, then I don't see a reason we need that. However, if Coterra would like to take the position that their 700 series well is within the Wolfcamp era rock and not the Pennsylvanian, then that is when I'll need the additional review and maybe a broader cross section, something trying to show that.
Yes, thank you. And I had the nomenclature mixed up in my brain. I was thinking the 700 was the upper Wolfcamp, and in this for Coterra, the 400 is the upper Wolfcamp. So I think Coterra I'll confirm with them on a break, but I think their preferred path forward, especially given the lease expiration issues, is to drop the 700 and 800 series wells and request that the 400 series well application move forward with the amended or revised exhibit packet that I will still need to submit, but should not hold up the actual case.
And then you're also recognizing that the CPAC will need to be updated to remove whatever series of wells is getting removed, correct?
I recognize that.
Okay. And
I'm hopeful. I mean, for this particular case, because I do have to amend the exhibits anyway, I understand that we'll have to come back. But I do believe that the division has allowed parties to dismiss wells from applications without requiring them to come back in the past when no other changes were necessary to the exhibit packet.
And do you have, okay, I guess if I can draw your attention to the CPAC for case 25805, Ms. Bennett?
Yes.
There appears to be a typo for well number 4. Actually,
Okay.
no, I'm looking at my note. I could ask Ms. St. Pierre about it more, but I believe that should be 804 is the number that should be saying there.
Yes, thank you. That's a cut and paste error. I appreciate you pointing that out.
Okay, and on the CPAC for case 25806, I don't have it directly in front of me, but my notes say that it has the reference as the horizontal spacing unit as being standard. Is that correct for what you're looking at? I can bring it up on my end too, if that's.
Yes, I see that I need to fix that on the CPAC.
Okay, so your intent would be to change that to non-standard, is that correct?
Yes.
Okay. Okay, so do you have an understanding, I guess, of what we're looking for both these cases now then?
I do, thank you.
Okay, thank you, Ms. Bennett. Thank you, Mr. Hearing Examiner. I have no further questions for these cases.
So Ms. Bennett, March 5th at the earliest?
Yes.
All right. Let's move on. We're in recess on those cases. Let's move on to Matador Production. I believe we have 5 cases here. I'm going to call the numbers out. That is 25821, 22, 23, 24, 25.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company. I don't think there are any other appearances. And at the outset, I will ask that we continue these cases to the March 5th docket. During the last handful of cases, we discovered a few notice parties that need to be perfected, and they are not timely today, but they will be in time for the March docket.
Well, I appreciate your bringing that to our attention. So why don't we just wait till March 5th to deal with them?
Perfect.
Okay, well, thank you, Ms. Starnes.
Absolutely. Would you like us to file a motion to continue or on the record?
Definitely.
Okay, perfect. We can do that today.
Mr. Hearing Examiner,
Mr. McClure?
if I may draw their attention to the CPAC for one of these cases.
Oh, please.
I have a feeling it's the CPAC for 23.
That's correct.
Go right ahead.
Ms. Starnes, I don't have it brought up before me, but on my notes, it references a incorrect section listed for the bottom hole location for the well. Do you see where I'm referring to?
Okay. Is it listed as section 10?
I can bring it up. My notes say it has the wrong section. I believe it's probably some error from being related to the one that's 2 miles long versus 1 mile long.
Okay. I will look into that and have it corrected for the March 5th docket.
Okay, thank you, Ms. Starnes. Thank you, Mr. Hearing Examiner.
All right, thank you, Ms. Starnes.
Thank you.
All right, moving on to, and just to give everyone notice, in 20 minutes, we're going to take a 2-hour lunch break. All right, let's go on to Mewbourne Oil. These are case numbers 25865, 25867.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of Mewbourne Oil Company.
Okay, good morning.
Good morning, Mr. Hearing Examiner, William Zimsky, Abity and Schill. We entered an entry of appearance for Devon Energy Production Company LP and WPX Energy Permian LLC. We're not objecting, we're just observing.
Thank you, Mr. Appreciate it.
Good morning. Good morning, Mr. Examiner. Jordan Kessler on behalf of EOG Resources. Like Mr. Zimsky, I'm just here to monitor.
Thank you, Ms. Kessler.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating and Concho Oil and Gas, monitoring only.
Thank you, Ms. Hatley. So before you go through your shtick, for lack of a better word, you didn't sign the CPAC.
Oh, perfect.
So that's an easy fix.
Yes, we can do that today.
We can keep the record open till the end of the day for you to do that.
Okay.
I don't believe there's any other issues in the idea of brevity. If you'll just let me know if your witnesses are experts, if the notice was timely, and any other crucial things you need me to know about these cases.
Absolutely. Both of our experts have previously testified before, and our notice was timely sent on December 19th.
So we'll accept all of your exhibits into evidence. Mr. McClure, is there any further review on these two cases?
No, Mr. Hearing Examiner.
Okay, as long as you get that signed CPAC into us, just revise, give us an amended exhibit packet.
Okay.
Explain in the cover letter, it wasn't signed, it's signed now, and the case can be taken, those two cases can be taken under advisement.
Perfect. Thank you so much.
All right, thank you. We're off the record there. All right, let's move on to Marathon Oil 25877.
Mr. Examiner Dana Hardy with Hardy McLean on behalf of Marathon.
Thank you. Go right ahead.
Thank you. And in the interest of brevity, would you like me to, well, our geology expert has not previously testified. So if there are questions, we would ask to have him qualified.
Mr. McClure, are you going to have questions for their geologist or just the landman?
Only the landman, Mr. Hearing Examiner.
So let's skip that today for qualification.
Okay, thank you. Marathon is seeking to pull a 1,266.6 acre standard horizontal unit comprised of irregular sections 7 and 8, Township 24 South, Range 27 East in Eddy County, and will dedicate the unit to the Atreides Federal Comm Wells. Ms. Shelley Klingler is our land witness who has been qualified as an expert and is available for questions. Our notice exhibits show that notice was timely sent on December 30th and January 13th. And we did timely publish on January 15th.
January 15, you said?
Correct.
Okay. Thank you. Your exhibits are admitted into evidence in this case. Let's get your witness on the screen.
Good morning.
Good morning. Ms. Klingler, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Spell your name, please.
Shelley, Shelley, Klingler, Klingler.
Okay, and I'm going to ask you under oath that you've been admitted as an expert before this division?
Yes, sir.
In what field?
Petroleum land matters.
Thank you, Ms. Klingler. Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Klingler, if I can draw your attention to your exhibit A-3.
Yes, sir.
Page 20 of 57.
Yes.
You see that like working interest spacing unit box / table?
Yes, sir.
Okay, and you have, or there's two persons that are highlighted there. Do you see what I'm referring to?
Yes, sir.
Are those the only two persons that Marathon is asking the division to force pull?
Working interest, yes. The only two working interests.
Now you clarify your answer with working interest, but my question is, are those the only two persons that Marathon is asking the division to force pull?
No, I have the override owners listed as uncommitted on A5. Page
Okay,
29.
so I get.
Sorry.
I guess looking at your exhibits, is it A6 that you mean, the commitment table?
Oh, I'm sorry.
On page 29.
Yeah, I was seeing A5 here on the screen, but it's page 29, A6, yes.
Okay, so then Marathon would like the division to force pull like all of those overrides or just down to Concho or not?
All the ones that are uncommitted.
Okay. Do you have in your exhibits anywhere where that's clarified?
I thought this was clarified here. Sorry. I can update the exhibit and I sent a new one to my council.
Okay, so if I ask for some sort of exhibit or amendment to these exhibits, it just makes absolutely clear as to the entirety of which person's marathon is wishing the division to force pool. Do you understand what I'm looking for?
Yes, sir. And my council has that to be provided at this time.
Okay, very good. Thank you, Miss. Mr. Hearing Examiner, I don't have any further questions for the expert witness, but I do have some guidance for, I know this was Miss Hardy or Miss McLean, whichever one, I guess.
Ms. Hardy, go right ahead.
Miss Hardy, on the CPAC, where it references primary product,
Yes.
do you see where it currently says oil on there?
Yes.
Could we update that to instead say gas?
Yes.
Okay, sounds good. And you got the list where we were going to need the amended exhibits in the landman for the
Yes.
overrides.
Yes, I do have that. Thank you.
Okay, thank you, Ms. Hardy. Thank you, Mr. Hearing Examiner.
Mr. McClure, the change from oil to gas seems to be a simple issue that we could leave the record open until the end of the day. The exhibit from the landman, is that something that would require further review once she highlights what interests they're seeking to be pooled?
Yeah, I think that's a pretty important thing because we're constantly, people need to know who an order applies to, and we
Okay.
need to have no.
Okay, sounds good. So March 5th, we'll review this case.
Thank you.
Thank you. All right, thank you, Mr. McClure. Thank you, Ms. Klingler. I guess you're gone. Anyway, let's go to 25883. This is Taprock Operating.
Good morning, Mr. Examiner. Miguel Suaza with Beatty and Wozniak appearing today on behalf of Taprock Operating.
Thank you, Mr. Suazo.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating, and we are not objecting to the case moving forward.
Perfect. Mr. Suazo, go right ahead.
Yes, thank you, Mr. Examiner. In this case, 25883, Taprock is requesting approval for a standard horizontal spacing unit and compulsory pooling comprised of 1,280 acres, more or less, comprised of the following wells: the Beer Cave Fedcom 202H, 204H, 211H, and 213H. All will produce in the Purple Sage Wolf Camp. There was a revised exhibit packet filed on February 3rd. That contains Exhibit A, which is the compulsory pooling checklist. Exhibit B is the application and the proposed notice of hearing, which was filed on December 31st of last year. And Exhibit C is the affidavit of Senior Landman Kenneth Maxwell. Mr. Maxwell has not previously testified before the division, and if you'd like, you can swear him in at this time.
I don't know if we're going to have questions for Mr. Maxwell. Are we, Mr. McClure?
I'll have questions for the landman.
Okay. Mr. McClure, are you going to have questions for anyone else or just the landman? I'm trying to decide on whether 10 minutes is enough time to do this case.
It should be just for the landman, and I believe it should be relatively quick.
Okay, perfect. All right, Mr. Suazo, let's deal with your exhibits first. Go ahead and finish what you were going to say about your notice and everything else.
Sure. Exhibits C1 through C6 are the standard suite of land exhibits, including the location maps, the C102s, the plat and tract ownership, and the ownership of the parties being pooled, well proposals, etc. Exhibit D is the affidavit of Vice President of Geoscience, Matt Jones. Mr. Jones has previously testified before the division, and his qualifications have been accepted and made a matter of record. His exhibits D1 through D5 are the standard suite of geology exhibits. And Exhibit E is the notice affidavit showing that notice letters were mailed on January 14th of this year to the addressees of record, the interested parties, and the mailing receipts and proof of publication was made in the Carlsbad Current Argus on January 22nd, also of this year. All notices were timely and contemplate holidays into the minimum days between notice and hearing. And with that, I'd like to request that the exhibits be admitted to the record and make the witnesses available for questioning. And hopefully this case can be taken under advisement.
Let's get your, admitted without exception. Let's get your landman on the camera.
I'm here.
I see you now. Okay, would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Please put your hand down and spell your name.
Kenneth, Kenneth, Maxwell, Maxwell.
Okay, and tell me what field of expertise you're seeking to be qualified.
Petroleum land matters.
Okay, what education do you have and when did you get it?
I have a Bachelor of Science in Mathematics from Texas Tech University in 2011.
Okay, what work have you done as a landman since 2011?
So I've been actively involved in multiple rig development programs for several different companies and in multiple different basins. Involves the negotiation of differing agreements that are needed to facilitate those multi-rig programs. Does that answer your question?
Somewhat. So let's see, who have you worked for as a landman?
So currently I'm employed by Taprock Resources as a senior landman. Previously, I was a land supervisor with BPX Energy, a subsidiary of BP, British Petroleum. Before that, I was with Jagged Peak Energy. And then before that, I was with a company out of Dallas, Besa Resources.
Okay, and what's your title now?
Senior landman.
Okay, I think you mentioned that. And what are your responsibilities generally as it is now?
So I'm actively involved in Taprock's development program of drilling wells, as well as acquisition A&D efforts, acquiring and divesting of various interests.
Okay, I recognize you as a petroleum landman from here on in. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Maxwell, I'm looking at your exhibit C-4, which is on page 30, I think, of 54.
Okay.
And do you see on this table where you have 5 different persons highlighted?
Yes, sir, I do.
Are those 5 persons all of the persons that the applicant, Taprock, is asking the division to force pull?
Yes, sir.
Okay, so there are no overrides or anything like that Taprock is asking the division to force pull?
There are overriding royalty owners.
Yep. Is Taprock asking the division to force pull any of them?
My understanding is that the working interest parties were the ones that needed to be force pulled.
Okay, so let me ask you one more time, just make sure I'm understanding what you're saying. So then is it accurate to say that Taprock is not asking the division to force pull any overrides?
At this time, no.
Okay, very good. Thank you, Mr. Maxwell. Thank you, Mr. Hearing Examiner. I have nothing further for this case, and I think we can take it under advisement.
Excellent. Let's end on a high note here. All right. Oh, for us too, we don't want to hear these cases again. So, now let's see, I got 5 more minutes and I have 2 cases I believe we can take under advisement. So let's get these out of the way. These are also Taprock. Mr. Suazo, are you representing 25884, 25885?
Yes, Mr. Examiner.
Let's get through these 2 cases. Go for it.
All right. In these cases, Taprock's requesting approval for 2 standard horizontal spacing units and compulsory pooling. In 25884, they're seeking approval of a 320-acre standard horizontal unit in the west half of section 17 and 20, townships 26 south, range 25 east in Eddy County, comprised of the Coors Fedcom 151H, which will produce in the Bone Spring. And in case number 2588, they're seeking approval of a 320-acre, more or less standard horizontal spacing unit in the east half of the west half of section 17 and 20, township 26 south, range 25 east, also in Eddy County, containing the Coors Fedcom 152H, also producing from the Bone Spring. The exhibit packet was filed on January 29th of this year. Exhibit A is the compulsory pooling checklist. Exhibit B is the application and proposed notice of hearing filed on December 31st of 2025. Exhibit C is the affidavit of senior landman Erica Shoemaker, who has previously testified before the division, and her qualifications have been accepted and made a matter of record. Exhibit C1 through C6 are the standard suite of land exhibits. And Exhibit D is the affidavit of Vice President of Geoscience, Matt Jones. He has also previously testified before the division, and his qualifications have been accepted and made a matter of record. His exhibits D1 through 5 are the standard suite of geology exhibits. And finally, Exhibit E is the affidavit showing that notice letters were mailed on January 14th, 2026 to the addresses of the interested parties. Mailing receipts and proof of publication in the Carlsbad Current Argus was made on January 22nd of this year. All notices were timely and contemplate the holidays into the minimum days between notice and hearing. And with that, I would like to request that the exhibits be admitted into the record and that these matters be taken under advisement.
Admitted without exception, taken under advisement. Thank you, Mr. Suazo, and have a good lunch.
Thank you, Mr. Examiner. You too.
We're off the record.